Okay, so I think we're going to get started. Can everybody hear me? If you can you just do a quick little chat box? Oh, perfect. Okay, so welcome everybody to the session here this afternoon. As you know, everything with 2020, it seems we have had to adjust and certainly go to a virtual format, but nonetheless, I'm very excited to be here with all of you for this session today here on specifically Bill 29 and the Local Authorities Election Amendment Act, where we can provide some information and describe some of those amendments that occurred here in just recently in July. Just a few housekeeping items before we get rolling. First and foremost, if everyone can please make sure they keep their microphones muted and their videos off. It just helps with the quality of the Zoom presentation. So again, if you can keep your microphones turned off and your videos off throughout the presentation, that would be great. If you are having issues with the sound, we are getting indications from folks that they can hear us. So it might be something on your end if you're having issues. But with that being said, as we proceed through the presentation, feel free to certainly provide your questions, ask your questions as we go. We will dedicate some time, probably about half an hour, at the end of the session to take those questions, but certainly don't hesitate to ask those as we go, and we'll be sure that we get those. We will be monitoring them as well to make sure, just depending on how many we get in. I did just see a chat come up about the slides. Yes, the presentation will be shared after kind of following the session. There will be a variety of information sent out to participants that I'll get into a little bit later. In addition, I just want everyone to know as well that we are recording this session. So just for FOIP purposes, I'm just letting everybody know ahead of time that it will be recorded, certainly with the intent of making it available following the session as well. Just a few kind of short introductions. I'm sure many of you will know me, but my name is Lorraine Ellis, and I'm the Senior Election Advisor here at Municipal Affairs. And I have a few additional folks joining me in the room today that are helping monitor questions and kind of helping us guide through this presentation. So just quick introductions. I have Jennifer Miskoski and Angela Bilski, whom I work closely with within advisory services here at Municipal Affairs. So always a resource for folks as well, and any of the advisory team, any of your contacts in Municipal Affairs.
I just had to, I just know I got it now. I had to go outside of my remote connection and log in like just from my personal laptop. Thank you. Okay, bye.
Okay, so just a reminder for folks to make sure that all those microphones are muted and videos are off just throughout the presentation to avoid any sort of interruption as we're working along. So as was mentioned in the session description as well, along with the LAEA and the Bill 29 amendments, we will be joined by Elections Alberta and specifically Pamela Renwick with Elections Alberta to talk specifically about the Alberta Senate Election Act as well as the Referendum Act. Very excited to be working in collaboration with Elections Alberta as we prepare for the anticipated Senate and referendum questions in conjunction with the 2021 municipal elections. So we will be joined by her a little bit later on in the presentation. I also just want to take a quick moment and extend a thank you to the Alberta Municipal Clerks Association for allowing us to utilize their virtual platform, this Zoom meeting platform. Unfortunately, as everyone is aware, sometimes 2020 has thrown us a few curveballs, and this was no exception, and adapting on the fly and being nimble is something that we've all gotten used to. So I really do appreciate the partnership with Alberta Municipal Clerks in utilizing the Zoom platform. So thank you for that. And with that being said, I think we are going to get started here. So first and foremost, a quick agenda for today. We're going to start, I'm going to take probably about 30 minutes or so and talk about what happened in spring 2020, kind of pre-COVID-19, and then we'll give you a general overview of the amendments from Bill 29, being the Local Authorities Election Amendment Act, which included provisions specific to campaign financing, third-party advertising, and all of those fun general clarifying and technical amendments that the regular person off the street may not necessarily care about, but certainly have some fairly significant implications for the 2021 municipal elections. We'll also address what the next steps are in terms of the next couple of months leading into 2021, and then I will turn it over to Elections Alberta to proceed with their information on Senate and referendum. I do just want to note very quickly that this is not 2021 election training. This is just an information session so that folks are aware of the amendments from July. As you know, I certainly understand that some folks may have not received that information yet. So we're going to focus on that today, and then I'll get to kind of what the next plan is for the 2021 municipal election training. So in terms of what happened in spring 2020, I feel like that is a loaded question because I feel like a lot has happened since February, March. But as many of you know, the government of Alberta, specifically Municipal Affairs, launched consultation on the Local Authorities Election Act on February 4th, 2020. That consultation focused mainly on areas of campaign finance and third-party advertising. There were some questions with respect to the campaign period, the nomination period, those sorts of things, but it did focus largely on that campaign finance piece. The consultation that was conducted included a broad public survey available to all Albertans, and that was available until March 4th, 2020. In addition to that, in-person engagement sessions were held with identified stakeholders, including both the municipal and school board associations from the elected official side as well as the administration side. And those were held the week of February 17th here in Edmonton. So following the consultation, the feedback was analyzed and was certainly taken into consideration with the intention of bringing amendments to the LAEA during the spring 2020 legislative session. However, as I think everyone is well aware, come the middle of March, COVID-19 threw a bit of a wrench into our plans, which included the timelines and legislative priorities of the government of Alberta, and the focus really shifted to ensuring the health and safety of all Albertans during the pandemic. So as a result of that, the amendments to the LAEA were paused while the government responded to those immediate needs of the pandemic. And then fast forward to June of 2020, specifically June 23rd, Bill 29, the Local Authorities Election Amendment Act, was tabled in the legislature, and following that, third reading was completed on July 21st, followed by royal assent on July 23rd, and ultimately the changes came into force on September 1st of 2020. In terms of the amendments, the first and foremost, as I mentioned, were campaign finance. And these amendments largely focused on the contribution limits. The contribution limits outside of the campaign period that defined that campaign period being January 1st to December 31st, 2021. It also included provisions with respect to review engagements as defined under the Chartered Professional Accountants Act. There were also adjustments made to candidate surplus and candidate deficits, as well as the minor adjustments made to the nomination period itself. In terms of third-party advertising, these changes really focused on the definition of the advertising periods, as well as what constitutes, I suppose, third-party advertising, so the definitions shifted slightly, as well as the inclusion of a provincial registrar as it relates to third-party advertising. And finally, the general clarifying and technical amendments, these were focused on the areas of the location to accept nomination papers, the withdrawal of candidates during the nomination period, provisions on vouching, as well as the disposition of election materials. So jumping right in to kind of explain a little bit further on those campaign finance and contribution disclosure amendments. The first and foremost, the contribution limits. So these were some of the largest amendments that occurred in Bill 29, and many of you will know during the 2018 review, these limits were adjusted to a $4,000 limit in the aggregate province-wide for candidates in municipal office, and then the same limit applied for candidates in school board trustee elections. Ultimately, what Bill 29 did was it raised those limits to a $5,000 per candidate limit. So, for example, a contributor now can donate $5,000 to as many candidates for municipal elections as they wish, as well as $5,000 to as many school board trustee candidates as they would like. So, kind of just a quick example of this is if I wanted to, here in the city of Edmonton, contribute $5,000 to each and every candidate that was running in my ward, I would certainly have that ability to do that now. So $5,000 to candidate A, $5,000 to candidate B, $5,000 to candidate C. It's no longer an aggregate limit. In addition to that, candidates do now have access to $10,000 of their own funds to contribute to their campaign as well. So as many of you know, 2018, that $4,000 aggregate limit did apply to the contribution that the candidate themselves could make. This was increased to $10,000 of the candidate's own funds can be donated to their campaign. In terms of the limits outside of the campaign period, like the contribution limits, these again were some of the larger amendments that we saw. So in 2018, these amendments were set at $2,000 in the aggregate outside of the campaign period. What happened was these were adjusted to a $5,000 contribution limit annually, plus a $10,000 limit on self-contributions made by an individual. So to clarify, what this means is that in each of, going forward, in each of 2022, 2023, and 2024, a candidate could accept up to $5,000 annually for the purpose of the 2025 campaign. In addition to that, a candidate could contribute up to $10,000 of their own funds in each of 2022, 2023, and 2024, again, for the purpose of the 2025 campaign. And some clarification around kind of what the story is right now. Between September 1st, 2020 and December 31st, 2020, a candidate could accept up to $5,000 in the aggregate, as well as contribute up to $10,000 of their own funds. And then beginning January 1st, if they do file their nomination papers right away, again, that's where the contribution limits that we spoke to just previously would kick in as well. So between September 1st and December 31st, it is foreseeable that a candidate could accept up to $5,000, as well as contribute up to $10,000 of their own money for the purpose of their campaign. In terms of review engagements, Bill 29 included a provision that requires candidates who incur expenses or accept contributions in excess of $50,000, that's 50, to file a review engagement as defined under the Chartered Professional Accountants Act at the same time that they file their campaign disclosure statements. So again, the threshold there is $50,000, 50, and they must file a review engagement in addition to their campaign disclosure statements. Another significant change was made to surplus funds. So surplus funds, as many of you know, if a candidate showed a surplus fund on their campaign disclosure statements, those funds were required to be held in trust by the municipality or the school board until that individual filed nomination papers in the next general election. And then there were provisions in the event that that candidate did not file disclosure statement, or pardon me, nomination papers. What has changed here is candidates are no longer permitted to carry a surplus in excess of $1,000. So if a candidate on their disclosure statement for 2021 shows a surplus in excess of $1,000, they are required to donate that surplus or a portion of the surplus that will result in it being less than $1,000 to a registered charity. And the registered charity is defined in the LEA as in accordance with the Income Tax Act. So again, surpluses in excess of $1,000 must be donated to a registered charity, or a portion of it that will result in the surplus being less than $1,000 must be donated to a registered charity. And the timelines for that are 60 days following the date in which they were required to file their disclosure statement. So those surplus would need to be disposed of within 60 days of the candidate filing the disclosure statement, which is defined in the Act as March 1st of 2022. In terms of surplus funds that are less than $1,000, those can be kept by the candidate and used as they see fit. So if a candidate has showed a $900 surplus, the legislation no longer, I don't want to say no longer cares, but the legislation no longer requires those to be held in trust or otherwise. They can be held by the candidate to do with as they see fit, or as well, the candidate does have the option to donate those surplus funds directly to charity as well. In the event that those surpluses have been donated to charity, there is a requirement within 30 days of the expiration of the 60-day period to file an amended campaign disclosure statement. Now, in terms of the transitional period, I know that this was a question that I did get yesterday. So with funds right now, the transitional portion of the legislation in Bill 29 states that surplus funds can be, again, they have to be disposed of before January 1st, 2022 with respect to any surplus that was carried over from 2017 or a by-election that may have occurred in that time frame between 2017 and September 1st of 2020. Those surpluses, for the purpose, the rules still apply in the same way. So surpluses in excess of $1,000 must be donated to a registered charity. Anything less than $1,000 can be used by the candidate or donated to charity. So the same rules apply. If a candidate came in today and requested that surplus back, the municipality can provide that. There's nothing in the transitional provisions that would prevent you from providing that surplus back. In terms of deficits, there was also a shift in the deficit. So ultimately, under Bill 29, deficits must be eliminated within 60 days of the March 1st campaign disclosure statement deadline. They do have access at that point to contributions for that 60-day period for the purpose of eliminating that deficit. So again, the $5,000 contribution limit per contributor would apply to those, as well as the $10,000 self-contribution limit. But the candidate does have access to those contributions for the purpose of eliminating the deficit. And the change here with the nomination period, as many of you know, the period of time between when nominations closed and election day was adjusted in 2018 to 6 weeks prior between close of nominations and election day. With respect to the change now, it is back to 4 weeks. So nomination period will start January 1st, 2021, and will run until September 20th, 2021, which is 4 weeks prior to Election Day. In terms of third-party advertising, as I mentioned, the largest changes here were around the advertising period. So in 2018, these third-party advertising provisions were added into the Act, and there was a distinction between election advertising and political advertising. In Bill 29, political advertising has been removed. So the only thing that remains regulated is the period of time known as the election advertising period. And that period is from May 1st to the close of voting stations on Election Day. So again, May 1st in 2021 to whenever your voting station closed, 8 p.m. On October 18th, 2021. Political advertising was defined as that entire period outside of that election advertising period. That no longer exists. In addition to that, there was an adjustment made to what constitutes third-party advertising. So issue-based advertising was removed, and so now what we talk about when we talk about third-party advertising is any message or advertisement that promotes or opposes a candidate. It's no longer issue-based advertising as well as the candidate side. It's just the opposition or promotion of the candidate being elected. In addition to this, the provincial registrar was added. So there was some concern regarding third-party advertisers being required to register in each and every municipality or school board that they intended to register in. What this does is this includes a registrar component where a third party, if they are registering in excess of 10 local jurisdictions, they register directly with the provincial registrar, and at that point the provincial registrar becomes responsible for maintaining the register, accepting the registrations, the third party filing the disclosure statements. All of the things that the municipality or the school board would be required to do would then fall to the registrar. But again, that is only applied if a third party is intending to or has registered in 10 or more municipalities or school boards. In terms of the general clarifying and technical amendments, these were changes that were reflected out of feedback that we had received since the 2018 amendments. The first being the location to accept the nomination papers. So in 2018, as many of you know, there were the changes made to the nomination period. What that resulted in was a clause in the legislation being inadvertently pulled out, which allowed for the municipality or school board to pass a bylaw to identify, additional locations to accept nomination papers. This has since been added back in. So what this means is a municipality prior to December 31st of 2020 can pass a bylaw that would allow for nomination papers to be accepted at more than one local or additional locations outside of that local jurisdiction office. This was one that was identified to us from our larger rurals who may have more than one office in the municipality, as well as our larger cities, and really was just reflective of some barrier that we became aware of in terms of where those nomination papers can be accepted. The withdrawal of nominations was also one that was brought to us with that longer nomination period. So essentially what this one does is it allows for a withdrawal of nominations during the entirety of that nomination period. So for example, if a candidate files their nomination papers January 15th of 2021, their situation changes. Either they move out of the municipality or otherwise become ineligible. They can withdraw those papers, for example, in April, rather than having to wait until the close of nominations 4 weeks prior to Election Day, and then having that 24-hour period to withdraw. So this is just reflective of that ability for a candidate to withdraw those papers at any time until the close of the nomination period. In this case, 12 noon on September 20th, 2021. With that being said, There is still the 24-hour grace period or withdrawal period as defined under the legislation, which is in the event that at the close of nominations there are more nominations filed than there are vacancies, a candidate could still withdraw within that 24-hour period. In addition, the provisions that relate to the inability to withdraw, so when there are acclamations, for example, so there are equal number of nomination papers as there are vacancies, a candidate would not be able to withdraw after the close of nomination to the 24-hour period following that. And in addition to that as well, there are still the provisions for the insufficient nominations, and that process has not changed. In terms of vouching, the largest change here is the ability to only vouch for one elector. The legislation never did address a maximum number of persons that an individual could vouch for. So what this does is this limits that to the elector vouching for one person. The caveat with this is if the elector comes in with members of the same household, and all of those individuals are from the same household, then that elector can vouch for every single one of those individuals in the same home. So for example, I come into the voting station, I show my ID, I sign my elector register, and then I am accompanied by someone that just moved into my neighborhood. I know who they are, but there are 6 of them living in the one home. I can vouch for all 6 of them. But if only one elector comes with me, I can only vouch for one, and then I'm done. So again, the maximum ability to vouch is 1, unless everyone is located in the same residence. In terms of the disposition of election materials, this has changed slightly, and I'm going to give a shout out to our municipal accountability program, in that this was identified as some situations that we were seeing where, yes, the legislation identified ballot boxes remaining sealed for a period of 6 weeks following election day. What we were finding was instances where many municipalities were not disposing of their election materials. There were instances where we were hearing of, elections from 3 or 4 elections ago were still being stored. What this does is it creates a finite period of time for those materials to be destroyed. So 6 weeks after election day, up until 12 weeks, all of those materials can be destroyed. So the ballot boxes, the seals can be broken, and materials can be destroyed. However, there's a caveat. If a judge orders otherwise, please do not destroy anything. If you have a court order saying that those ballot boxes cannot be opened or the contents destroyed, please do not destroy them. Unless, everything being the same, if you don't have that court order or a judge's order, you must destroy those materials 6 to 12 weeks after election day. Okay, in terms of what is next, as many of you know, Municipal Affairs did release frequently asked questions and information sheets following the 2018 amendments. Those resources have been updated and they will be put onto the website for access, as well as we will include them on the information that we send out following this session as well. So anyone registered in this session will receive those information sheets, those updated sheets. Another big question that we received was questions about the 2021 municipal election training. So as many of you know, COVID-19 has prevented us from gatherings, maintaining socially distanced, just being more mindful of those in-person training opportunities. So we have adjusted accordingly. And with that being said, there is plans for Municipal Affairs to do module-based training for the 2021 municipal election that will be broken down into smaller pieces as we get closer to election day. So it is certainly our intent this fall to provide 2 sessions or 2 kind of groups of sessions I should say. The first being on anything and everything that you need to know in terms of pre-election considerations. So anything that needs to be done before December 31st, that will be one session. And considerations just overall for the 2021 municipal election. And the second session will focus largely on the nomination process. So what you need to know to be prepared for January 1st, and what you need to know in terms of candidate eligibility, those sorts of things. That will be the focus of Module 2. In addition to that, just a quick rundown of the important dates in 2021. January 1st, you must be able to accept a nomination paper. So that is when the nomination period officially begins. May 1st marks the election period for third-party advertisers. September 20th is quote-unquote nomination day, or is when the nomination period officially closes at 12 noon. And finally, everyone's favorite day, everyone's favorite day every 4 years anyway, is Election Day, October 18th, 2021. So those are kind of the next steps with respect to training and information. It is certainly our intent to also update our resources, such as the candidate manual, the returning officer manual, all of those resources that we have done in the past as well. It's just, we ask for patience at this point, just given how late those amendments were passed, just given some things in the legislative session, in the calendar, and those not being passed until late July. The other thing that I just wanted to mention very quickly is certainly that it is not the intent of any municipality to be open on January 1st of 2021. We recognize that as a stat holiday, and we recognize that all of your offices are closed. The Interpretation Act applies for that clarity and allows you, it would essentially fall to the next business day. The way in which we draft legislation is we pick kind of those first dates of the month. So the Interpretation Act kicks in at that point. So certainly no requirement to be open on January 1st, and it would fall to the next business day.